You know, I was wondering, I guess it was when you're sitting on the cake and it's there you go. That's good.
Ladies and gentlemen, we're about to open the Speakers Committee on Workforce Standards and Development. I'd like to ask all the representatives, please conduct yourselves with the decorum that's expected of us, and those in the audience to help us attain this goal. With that, Madam Speaker, would you please call roll? Here.
Representative Dohrman. Representative Bratton. Burns.
Here.
Carpenter. Breaker. Dawson.
Here.
Kelly. Lant. Smith. Walker.
We do not have a quorum, so pertaining to the rules of the House, we will conduct this meeting as a subcommittee until such time as a quorum arrives. At this time, we will hear House Bill 1722, sponsored by Representative Weeman. Would you please go ahead, sir?
Mr. Chairman, members of the committee, for the record, my name is John Weeman, State Representative for District 103, St. Charles County. Today I'm presenting House Bill 1722, titled Public Employee Labor Organizations. House Bill 1722 pertains to public employee labor organizations or unions. The purpose of this bill is to address transparency and accountability of all public sector labor organizations on behalf of their members, and most importantly, we the taxpayers. I want to emphasize that this bill is not anti-union, has nothing to do with right to work, and does not prohibit public employees from organizing or negotiating collective bargaining agreements. The Missouri Supreme Court ruled in the 2007 case, Independence NEA versus Independence School District, that public employees were covered under Article 1, Section 29 of the Missouri Constitution to have the right to organize and bargain collectively through representatives of their choosing. House Bill 1722 specifically addresses four main issues, which I'll take a moment to go through those real quickly. First one, Missouri public employees should have a say in deciding who best represents their interests. Most current government union members have never voted to choose a representation or to continue being affiliated with that specific union. Currently, it is very difficult, if not impossible, for members to force their government union to conduct a recertification election. This bill allows public employees the option to renew their current representation by requiring recertification elections every 2 years. Second main issue that this bill addresses is Missouri taxpayers should have the ability through open meetings and records to review and provide oversight on how their tax dollars are spent on public sector collective bargaining agreements. Currently under Missouri Revised Statutes, Section 610.021, it authorizes a public governmental body to close meetings, records, and votes to the extent that they relate to the following under paragraph 9, which deals with preparation, including any discussions or work product on behalf of public governmental body or its representatives for negotiations with employee groups. Missouri taxpayers should have the same right to access government union contract negotiations as they do with other government-related hearings and meetings. House Bill 1722 will make government collective bargaining agreements meetings as public and documents presented by a public body during a meeting concerning a labor agreement or that the public body receives from an employee association to be considered a public record. Third issue. Missouri public employees should be entitled to know how their government union spends their dues. Currently, private sector unions already file financial disclosures with the Department of Labor for their members and the public to review. Unfortunately, government unions are not held to the same transparency and accountability standards. This bill would require annual financial reporting by government unions to include financial assets and liabilities, itemized expenditures, union officer and member salaries and benefits, lobbying expenditures, and political contributions. And fourth, finally, Missouri government and taxpayers should not be bound indefinitely to unsustainable labor agreements with government unions. Currently, many government or public sector labor agreements contain evergreen clause that can bind parties to agreements for many years beyond the original term, therefore limiting the ability of governmental bodies to modify unfavorable collective bargaining agreements later in the year into the contract tenure. This bill will prohibit any government union contract from exceeding 2 years in length. In closing, Mr. Chairman, this bill was written to add more transparency and accountability to public sector unions in the state of Missouri. This concludes my opening remarks, and at this time I'd be happy to answer any questions.
Other questions from the committee? Representative Burns.
Basically, I have a statement.
Representative Burns, we'll have to hold these to inquiries.
Okay, well, I'll inquire, okay. And permission to Mr. Speaker, Chairman, sorry. John, I am going to ask you some questions. The first one is, you and I have talked about your background, and I've looked on, I would usually read everybody's bio, and I noticed that you're the same age as my oldest son. So, but when I let you bring this bill, I know you said your grandfather was in union and your father, but I look at this and I understand about transparency, but why would you be bringing this bill? I understand about openness and all those things, but you're buying a very successful insurance business, and I think you and I have just taken different paths, which is wonderful. But why are you bringing this bill, which has to do with a labor organization?
Appreciate the question, Representative. The bill is specifically dealing with the public sector labor organizations. It is obviously dealing with labor organizations, as you had alluded, but it's more specifically towards the public sector, and I think that's where our concern is. It's just that we feel like in the private sector, there's a lot of current rules and regulations in place and laws in place to protect the private sector union members, but there's not the same that's afforded to public sector union employees. And so that's part of my reason for wanting to move this bill forward, is to protect those members of government sector unions that need that additional protection and transparency and accountability from their unions.
Okay, my whole point is I'm really going to not ask a lot of questions because I would like to hear all the witnesses on either side testify. We ask too many questions, that ties it up. So thank you, and I'll save any questions I have till the end. Okay, thank you, Mr. Chairman.
Other questions from the committee? Representative Wheelan, would you like to bring your first witness in support, please? Sure.
Good afternoon, ladies and gentlemen. Just take a couple minutes of your time. My name is Chris Estes. I'm currently the serving elected assessor in Polk County, Missouri. I am not.
Please speak into the mic, sir.
Sorry.
Thank you.
My name is Chris Estes. I am currently the serving assessor in Polk County, and I'm not here in an official capacity as an assessor or representative of Polk County. I'm here because I've had experience in public sector unions and private sector unions. I've been a construction contractor for quite a few years, had experience with private sector unions. I was also with the Missouri Department of Corrections and the Missouri Fraternal Order of Police. And I've had some experience with both of those groups. My feelings are that anybody in the public sector, elected official, state employee, county employee, we work for the taxpayer. And everything we do or are involved in should be open to those taxpayers. I know of circumstances in organizations where it's supposed to be representative of the members in that organization. Sometimes you find that the organization is not listening to the members, even the majority of the members, and doing as they please. There are also times that there's information passed back and forth, contracts, negotiations that some of the members aren't made aware of, and obviously the public's not made aware of. And I believe that this is a situation where these people need to be answerable to the taxpayers, just like every elected official is and every state employee should. Thank you.
Questions for the witness? Hearing. Thank you very, very much, sir. Mr. Otto Fajan, opposing bill.
Thank you, Mr. Chairman. As you mentioned, Otto Fajan speaking on behalf of the Missouri National Education Association. We would like to go on record in opposition to House Bill 1722. There are a lot of provisions in this bill. I presume that our testimony should be as brief as possible. And so what I'm really trying to do is kind of sketch our association and our members' primary concerns. And I want to start by just kind of having we keep hearing these bills that seem to articulate a concern that whether it's our membership or the public, somehow the process that we already have doesn't work. And time again, when I'm working with members, with leaders, I never hear that from my folks. I was just with over 130 of my folks and 13 legislators on Saturday morning, and we were talking about what is it we need to do, what you all and the state board need to do about good education for our kids. That's what's on our minds. And my members unanimously, from all of my interactions with them, which are many, do not express, hey, we really need to pass one of these sorts of things that's putting in place provisions that relate to the processes of organization and unions that are already well covered by smart laws that have been on the books for many, many decades. We spoke to those concerns when it came to the paycheck bill a couple of weeks ago, and we kind of feel like we're kind of in Groundhog Day, that'll be tomorrow, with similar concerns here. I wanted to step back and remind us that we've got federal law since the 30s that deals with collective bargaining and labor. We've got in Missouri from 1945 a constitutional provision that speaks to the rights of every employee. And the INEA decision only 9 years ago said, yes, all employees means public employees. Those exist for two purposes. They're both to help employees and to help management. Because ultimately, since the 30s, we've known, as other countries around the world that are world leaders that have these stable bargaining relationships, they know good, stable bargaining relationships between labor and management are going to be good for economic success, for businesses, and in the context of my folks working with the administration of the school board in providing good education for students, which, as I said, that was all our conversation was about on Saturday morning. This bill will impose a lot of new stuff, impractical requirements on employees and employers that are going to undermine those stable bargaining relationships. And I want to speak to something that is particularly true as it relates to educators. The election mandate is especially troubling for educators. Now, of course, we all know that our 100,000 education employees, they're free to join or leave any of the organizations that represent educators anytime they want. And they have to they have to say, we desire to seek recognition. And there's a process for that the union does not control. But in our particular case, it's a little different. And this bill is particularly troubling. Teacher bargaining, like bargaining as it relates to law enforcement, it's not covered under the public sector bargaining law in Chapter 105. We have the constitutional bargaining right, and that's about it. What that means is that it's really under the control, the local control of school boards to set this process. They get to select a process that suits the needs of the district and the staff, and in particular as to the time, place, and manner of the representation election, and also who conducts it. I live in Columbia. I was born in Columbia. I'm probably going to live my entire life in Columbia if I have the opportunity. Columbia Public Schools teachers are currently represented by an elected local, the CMNEA local. And the Columbia School Board chose to have that election and have it run by the League of Women Voters. That suited Columbia, that suited our district. The election was carried out by the League of Women Voters in Columbia, times and locations that made sense for the district, for the league as the proctors of the election, and for our members, and for all the eligible voters in the bargaining unit. Now, of course, we had some concerns that somehow that's an irrevocable decision. Missouri law and process also calls for a smart process to allow bargaining unit to change its mind, and that exists. And it's not something controlled by the union. There's a process if you're covered under 105 that relates to how the State Board of Mediation would conduct a similar election. And the school board is required under the law to have a similar process. This arbitrary mandate of that recertification election every 2 years, piled on top of the fact that it's on a general election. School boards never choose to have this election on a general election day. That doesn't make sense. That doesn't work for districts. We never see that. We would never advocate for that. It's going to leave both the employers and unions in a less stable bargaining situation. There's going to be uncertainty. There's going to be a lot of extra trouble in terms of the administration of the election. They won't know if the employers, sometimes they come to the union and they say, we think there are some things that we should have in the bargain agreement that we'll implement together for the service that we provide to the public that needs to be in place for longer than a particular period of time that this bill might spell out. So once again, we're going to urge the committee to consider the collateral damage that this harmful proposal will cause to employers, to unions, and to stable bargaining relations around the state. I'll point out that these are voluntary agreements. There's no compulsion for the board and the union to agree to anything, but these voluntary agreements in districts all over the state, we find they promote excellent public service. And in the case of education, they promote good education. We strongly oppose House Bill 1722. We'd be happy after the committee hearing to put the committee in touch with district administration and government that we believe would be concerned if they thought this bill was moving forward in a substantial fashion because of the impact it would have on the stable bargaining relationships they rely on. But for all those reasons, we strongly oppose the bill. We'd be happy to answer any questions.
Questions for the witness? Representative Burns?
Have my inquire
Go ahead.
very briefly.
Yes, sir.
I served on the Board of Education of Afton School District for 12 years. Our teachers were the AEA, Afton Educational Association, and a member of the MEA.
One of our locals, absolutely.
We only had, and then my question is, this happened in all the districts around the state. We didn't have negotiation, it was meet and confer. We were not bound, and when I got on, it was there, and for 12 years, I was there, worked quite well. It's never negotiations, it's meet and confer. And is it that way all over the state?
I'll just point out a couple of historical facts. The first one is that the meet and confer law was enacted in the 60s in Missouri. That was a time when you started to see states enacting those laws, but teachers were explicitly excluded from that. And we had, where the leadership of the school board was already of a mind, we need to have some kind of meaningful relationship. There were things that walked and talked a lot like a bargaining process, but it wasn't under the color of real recognition of law. For real, this is a bargain agreement, because the interpretation of from 1947 to 2007, when the Supreme Court case law was, all employees doesn't mean public employees. And then in 2007, when the INEA case came to the Supreme Court said, what were they thinking in 1947? We can't manufacture words that aren't there. All employees means all employees. That means public employees. At that point, the Supreme Court case law said the constitutional right that is guaranteed in Article 1 applies to all employees. At that point, it became clear that when there's negotiation, that it can actually be enforceable, that it can really be meaningful and enduring. Before that, it was essentially more like just a dialogue.
Well, I was asked, because of my background's all on unions, was I ever like on the other side of the fence? Elected board member in the state of Missouri, you are the fiduciary agent of that school district, which means you must have good stewardship over the funding, because that's all for children's education. Every penny you spend outside of that, legal action, anything, takes education money away from students. So I did have to watch all that stuff in a management position. But I'll guarantee you the board I was on was very fair, because the people who are teaching your children are teachers. They're handling the future of this world, not widgets. So we wanted to meet and confer and listen to the teachers, because they're the ones that you want to have decent salary, happy in their job, because they're teaching the children. And that's all I'll say. Thank you.
If I could respond to that, ultimately, Missouri has a really smart process, because the school board is essentially in the driver's seat. It's their decision. There's no provision in the law that says you have to come to a collective bargaining agreement with the local union unless you feel like it works out and it is something that you want to proceed forward with. And so the other thing that we need to bear in mind is school board members, there are members up every single year for election, and the terms are pretty much 3 years. So everybody's up within a 3-year period. There are opportunities to engage every week that the board meets to express concerns. And obviously every year there are opportunities for the public to express the concern in terms of the electoral process. But there are opportunities, every week when the board meets. So there's a process that's very smart, that's already in place and working very well all across the state.
Representative Carpenter, go ahead.
Thanks. I appreciated your commentary about the locality, how it's, we have sort of local control over these issues. And we hear a lot here in Jefferson City about the importance of local control. And when you see a bill like this that, fiscal note on it is $4.5 million, 21 full-time employees to enforce this, right? Well, it's millions of dollars for, you mentioned that it's burdensome regulation. And when you look at the bill, you look at the bill, page 3 all the way through page 9 and beyond is this reporting requirement. And I hope everybody on the committee takes the time to read it word for word, because it's really pretty amazing what the bill calls for. Talk about burdensome, talk about it starts to make sense why it would take 21 full-time employees to enforce this, why it would cost millions of dollars, and obviously it's a big burden on public employee unions. So doesn't it feel a little, out of step with sort of the stated agenda here in Jefferson City, which is to encourage local control and to not have burdensome regulation and not spend extra taxpayer dollars on this kind of stuff?
That certainly is the gist of our testimony. That is, we really want you all to consider the collateral damage, the kind of intrusion on, and in this case, as it relates to the folks I'm speaking on behalf of, it's pretty profound, because the State Board of Mediation does not control this. The school board does, and they set up the aspects of the process, and this is completely intruding on the decision-making process that they already have in place.
Thank you. Any other questions? Thank you very much.
Thank you so much for the time.
Mr. John Wright in support of the bill. And ladies and gentlemen, I notice that we do have a quorum at this time, so we will be operating as a full committee. Thank you.
My name is John Wright. I work for the Show Me Institute. I do labor policy. This bill includes a number of important pro-worker reforms. I want to focus mostly on the union elections, but to your point about those reporting requirements, federal law says that private sector unions have to make those same requirements. They've had to do that since the 1950s, since 1959, part of the LMRDA. It's just a transparency thing. It helps private sector unions, private sector union members hold their union accountable, see what their dues are going towards. As long as the private sector has been doing it for years and it's been okay, it shouldn't be a burden for the public sector unions. But we can differ on that. So I want to talk about union elections. The union elections that this bill would propose are particularly important for preserving worker freedom. Imagine we voted for our public officials only one time and for a lifetime appointment. And then after that initial election, the only way to remove a governor or a legislator from office was through an impeachment process. This wouldn't be fair. So why does unionization work this way? In Missouri, once a union becomes the exclusive representative for a group of public employees, that union remains in power indefinitely. Another election is not scheduled unless employees organize, petition, and gather enough signatures for what's called a decertification election. There are decertification elections, but there's about 9 times more certification elections than decertification elections in Missouri for public employees, and that's because of the asymmetry between the two processes. In some cases, employees are punished for attempting to decertify the union. I'm not talking about illegal coercion, which may or may not go on, but in one recent case, a government union successfully sued a group of employees for thousands of dollars for attempting to decertify it. It was a case out of Kansas City. I can go into the details if there's interest. The automatic union elections proposed by this bill would solve these problems. A regular secret ballot election serves as a good check on the abuses that may occur when a representative body is not accountable to its constituents. It's what we use to keep our public officials in check. And without that safeguard, we could not call our form of government democracy. The benefits of union elections are clear. Some of the union executives may oppose these elections because it requires them to run for re-election every couple of years. But the rank and file union members, this is a benefit to them because it allows them to hold their leaders accountable. One concern that was raised at that fiscal note, the Show Me Institute published a study of the cost of this type of union election last year. In it, I showed how Missouri could hold union elections that would not cost taxpayers a dime. In this study, I found that the monetary cost could be reduced or eliminated if the union election statute included language that, 1, encourages the State Board of Mediation to contract out for election services, 2, allows for alternative methods to traditional paper ballots, such as telephone or internet-based voting, and 3, requires unions to pay for the remaining cost with a small filing fee. Now, this bill incorporates all 3 of these recommendations, and it has almost the same fiscal note as last year. Actually, they inflated the cost, so I don't know what that's about. But if properly implemented, this bill can deliver the benefits of a more accountable government union without forcing taxpayers to pay for it or burdening the unions. To conclude, this bill provides several positive labor reforms that benefit both taxpayers and public employees, and these policies would be a good first step in improving the accountability of government unions in Missouri. Thanks.
Representative Carpenter.
Okay.
Go ahead.
You cited federal law in defense of why we should do this, but isn't it the case that we have decades of federal law regulating this area, and the federal law actually doesn't do what the bill does?
No.
So if your defense of why we should do the bill is because of federal law and federal law is good, then why don't we just stick with federal labor law on this issue?
No, that's a great question, because what the federal law does is it applies to only federal public sector unions and private sector unions. And there's nothing for Missouri public sector unions. As Otto just said, gave a little bit of the history of public sector unions in Missouri and how that came about, and how the first statute passed in the 60s, the teachers were excluded. It wasn't until 2007 when teachers could officially collectively bargain. The courts have been expanding public sector unions for decades, and the legislature hasn't acted, and they haven't included some of the same safeguards that are there to protect workers in the private sector. So With respect to the transparency issue, that's just bringing them up to the same level.
Okay, but to be clear, federal law doesn't impose these regulations, right? Which is why we have the bill before us today.
It imposes the federal, it includes the,
Well, if federal law already did this, we wouldn't have the bill, is that fair to say?
it does it for the private sector and not for the public sector.
Okay, so, but again, doesn't it seem a little disingenuous to cite federal law as a reason?
No, because federal law doesn't apply to public sector unions in Missouri, to Missouri-only unions. That's just not what they have the authority to regulate. Congress doesn't have the authority to regulate Missouri public sector unions. So, yeah.
Thank you, Chair.
Representative Burns?
Again, just permission to inquire, and these questions keep coming up. First of all, we swear to a supremacy clause in our Constitution, and as part of the United States Constitution, that supreme law is, federal law is supreme. Now, this is, which probably be court challenged, supreme law is a federal law. It's going to supersede over this new bill. That's my first question. The second one is, according to what Mr. Representative Carter brought up, this has a budgetary note of about $10.5 million. Where's that money going to come from? That's what the budget notes here talk about. Where is this money going to come from? Because we're so constrained on our state spending and our budget, everything that's brought in, like hiring these new employees, and if the state's going to pay for this, there's no money to pay for it. You got to take away from something else. That's the second thing. The last thing is, I'm glad that it also includes teachers M&EA, because as it was brought out in the governor's State of the State address, the most improved school district in this state with test scores and raising standards to the wonderment of everybody and done a great job is Riverview Gardens. Show Me Institute, or the same gentleman who started Show Me Institute, his group was going to sue Riverview Gardens School District because they weren't or Melville, because they weren't going to take enough student transfers to Melville. So, gentleman who started your Show Me Institute, what's his interest in going after a school district when it could be improved like Riverview Gardens? So, what is your real interest here if it appeared that his interest was going after a public school system that was already successful, and after one that was failing, and under the present laws, now it's the #1 performing district in our whole school, in our whole system in the state of Missouri? So those are the 3 questions I have.
Okay.
Thank you, Mr. Chair.
I'll try to remember what else. So you asked about our founder. Our founder is not our director. Our founder doesn't set our agenda. Our director sets our agenda. All right. Secondly, you talked about the cost here. I did this study last year, and it talks about the cost of labor reform. It talks about the cost of these union elections. They can be very affordable. It can be $1.50 per voter that's participating in the election. If you contract out and you do the right things that I recommend here. Wisconsin does this, and it does it very, very affordably. It doesn't burden the unions, and it does not cost the taxpayers a dime. So if you follow this, and I think this bill does do that, then this shouldn't cost what the fiscal note says it costs.
Then why is the fiscal representative candidly and respectfully, why is that fiscal note on there?
Well, Representative, I got this fiscal note literally about an hour ago, and in reviewing it compared to the fiscal notes that were from the same type of bill from last year, it's drastically different. I don't understand why this number, they must be following, I hate to say it, but I think they're following Common Core math here, because this doesn't match up even close to what the fiscal budget was, or fiscal note was from last year, the same bill with the same language. So I have no answer for you on why
What would
this
the fiscal note be?
Well, if we're following his recommendations as
Well,
far as what other states are doing.
I wouldn't take that. I mean, that just me personally as an official thing. I would take your word and where it comes out of our budget office. And if this is wrong, then that should be presented, but we should have an accurate budget note that comes from our people who prepare these bills. And that would be the official budget note. So I mean, if there's an estimation, that would be better than something privately brought in. I mean, I'm not trying to disrespect you, sir.
Representative, I think we're getting off track here a little bit. We'll get a fiscal note updated.
Thank you, Mr. Chairman. I'll stop questions and thank you.
And we go to select committee, we'll have an accurate fiscal note. Other questions of the witness? Representative Bratton.
To inquire.
Go ahead.
Gentlemen, thank you for your testimony. In speaking of the fiscal note, last year I didn't file the same bill, but I had one similar. And I have the actual fiscal note of my bill last year that basically did the same thing as a zero fiscal note. So I guess I have it right here. I'd be happy to pass it out to the committee. That would require a vote every 2 years. And the fiscal note last year was $0. And could be up to $289,000. So yeah, I kind of question this fiscal note as well of where they're getting their numbers. It sounds like they're, really trying to inflate this. But speaking to putting a target on the back of an individual or individuals that are trying to, decertify the union, it absolutely does put a bullseye right on their back. I mean, by the process that's already required, already set forth, they have to put themselves out and could very well become targets of disgruntled people that are for the union, but could take out on them. And I think putting in place a structure such as this, removes that and allows, the members to speak and to say so. So thank you for your testimony. I appreciate it. Thank you.
Thank you, sir. Andrea Flinders, in opposition, please. Bob used your time.
How does he use my time and I'm a different committee member than he is? Now, this ain't right. This ain't right. It's a clown show. This ain't right. He used my time. Okay.
Hi, I'm Andrea Flinders. I'm president of the Kansas City Federation of Teachers and School-Related Personnel. And our organization wants to go on record in opposition of this bill. I vehemently disagree that this bill is about transparency and accountability. I believe that what this bill is really designed to do is to silence the voices of our workers, to make things so cumbersome for unions, whether we're talking about the guidelines, the timelines, the fees, that eventually it will be virtually impossible for many of our, especially small locals, to exist, but for unions in general to spend all their time on paperwork instead of representing members. I think it's important to understand that, what unions do is they provide balance, and they provide balance with management. Management doesn't always know what's going on in the work site because they're not the ones doing the work. They're not the teachers. They're not working with the students in our classroom. And I think it's important to understand that we work very closely with our district, with our school board, and with the administration to make sure that our kids and the communities they live in, that they have the best resources possible. What this bill would do, would make make it very difficult as an organization to focus on the needs of our kids, to make sure that our teachers and school-related personnel had a voice in what's doing. I think the other part about the other part of this bill that concerns me greatly is that it's not just the 2-year recertification process that would be mandated, but that it's not any, from what I understand, any public association, any association that represents public employees, which is a pretty broad statement, can all of a sudden come in, be part of that election, not knowing anything about education, anything about children, and all of a sudden become a majority representative. I think also if you all of a sudden you have 3 or 4 of those associations running against each other, no one gets a 51% majority, and therefore there's no representative at all for the people that work with their children. So having said that, I just want to say that I sincerely hope that you will vote in opposition to this bill. I'll take any questions.
Do we have any questions of this witness? Okay. I think we'll stand in recess here for just a few minutes. We certainly want to give all the members an opportunity to question the witnesses. So let's take just a few minutes here and make sure that the members that left the room have an opportunity to question the witnesses. we'll take about 5 minutes here and see what, where we go from here, okay?
We'll now reconvene. Are there any questions of the witness, Ms. Flinders? Not appearing in that case. How about in support of the bill, Jeremy Katie?
Hello, Chair and Committee. My name is Jeremy Hay with Missouri Alliance for Freedom. I was just wanting to go on record in support of this legislation. And also wanted to drop off a witness form for Carl Bearden, United for Missouri, also wanted to go on record for this as well.
Any questions of the witness? None appearing. Thank you, sir. Mr. Clark Brown for the opposition.
Good afternoon, Chairman, honorable members of the committee. Clark Brown from SEIU, Service Employees International Union, our state council. I would make the introduction. We do have public sector employees. Hearing last week, I had informed you we have about 13 public contracts that we have in the state, and 3 of them are with the state of Missouri. So I hope some thoughts here can help you in your consideration about this legislation. I think first of all, we wanted to talk about the issue and the reason of necessity. And I'm not trying to be repetitious here, but sometimes legislators don't know there is an existing process for employees to have this choice of a union. And this comes around almost as frequent as what you're proposing in 2-year elections. Any time that a contract becomes open, workers have a right to run an election. And frankly, you can get that election run with less of a percentage rate of what it's talking about, which clearly says this is swung away, a little biased. Clearly can get this election conducted with a less percentage of what they have to vote to continue to keep their union in place. So I want to make sure of that. I think on the surface, this bill, you know, the sponsor, that's fine. I think we all have some differences of opinion. He wants to propose this legislation. It's about the employee's choice that this election comes around every 2 years, and that this is about accountability for workers. But I think really the real issue here, and when you look at the 9 pages plus of this bill, we're talking about a host of very bureaucratic appearing looking reform issues that are very broad and overreaching about currently what we have to do. There are just a couple I want to come touch on that others maybe have. This election process every 2 years, this is very cumbersome about putting it on election day. I can tell you that there are some workers that are so passionate about their union. In fact, this may impede getting them to do their civil duty of a regular political election for a presidential candidate, if that might be on that cycle year. I clearly see that we're stretching this window. This proposes they have a 7-day window of voting time. I mean, we don't offer that right now unless you have a bona fide absentee reason to do that and vote in advance or something. Also, I'm a little confused about this fiscal note. I didn't think one existed, and I appreciate the sponsor saying that just came up. I looked at the representatives from last year that had that. Of course, he didn't have all these reform issues in there, but there was a claim for 200-some thousand. But now that was the first year of it in accomplishing just half of the elections. I think that fiscal note doubles by the time you get 2 years into that. But I still question even that. There are not enough election judges to run around. When I called last year and informally requested from the State Board of Mediation, there are 637 certifications of public unions. I know because I've been a rep for 20 years alongside of doing the political work, that these reps can't fly around each place like that. I certainly would have some concern as a union member, which it was 20 years before I became staff of the union, about some privatized effort for me to cast my ballots. I want the State Board of Mediation to do my election, not some contracted firm to do this. And I can't even remember the number of that. It was 200 temporary employees all across the state to do this. Not comfortable in our eyes. Frankly, that fiscal note that I saw about this election process last year, I want to say here, I think that what this legislation is doing is setting fees involved to the unions, which is actually the members' dues money to have these elections run, is trying to offset the fiscal note period on this. And I think that that's something you should consider. Is it right to charge the members' unions or their union dues monies to pay these fees to have elections done? You know, the other areas, the meetings, the reporting, I'm not here to argue that. I think this is some kind of an attempt of some overreaching reform. But I will tell you about the terms. This legislation also sets up that we're going to end up with contracts in the last 2 years. I can tell you the 3 contracts we have with the state of Missouri are 3-year term contracts. That is what the state of Missouri wanted to do with us. Frankly, turning around in some cases, asking employers to do 2-year terms may not be what they want to have a task of doing every 2 years. I will tell you too, I question that. I think that's an arbitrary decision that you're trying to put in statutes that is typically bargained and agreed upon by the employer and the employees in their union bargaining. And they can sometimes be as much as 5 years, I've heard. Outside of, again, as the sponsor said, and the chairman, maybe this fiscal month needs to be looked at. I wouldn't doubt it's $10 million by the time you hire 21 staff to run around and do this. But I want to say, I think all this is unnecessary. I think there's a system in place for elections to be done anytime an employee is dissatisfied. I've been through one myself with a public entity. And that, in fact, this is a bunch of hurdles for employees, a burden for them to want to have to run and vote on their union every 2 years. And I think too, it's a burden for some of the employers to prepare for this and have time off or whatever's arranged from the workplace to go do this election stuff when there's an existing process. So just those couple of points. Be glad to answer any questions if there might be.
Questions for the witness? Not appearing. Ms. Rachel Payton, in support.
Hi, I'm Rachel Payton, Deputy State Director with Americans for Prosperity Missouri Chapter, and we just want to go on record in support of this legislation.
Reverend Martin McLennan, is that correct? Raffanon. Thank you, sir.
Mr. Chairman and committee members, thank you so much for the opportunity to speak. I am a pastor in the Evangelical Lutheran Church in America, and I come representing the workers' rights boards of Missouri Jobs with Justice, both in St. Louis and in Kansas City, and also over 500 people who attend Faith Labor Alliance meetings across the state. We heard about this legislation just at the end of the week, and we wanted definitely to voice our opposition to HB 1722. I have materials that I want to, letters and testimony that I want to deliver to you all. We have 15 clergy from around the state that have written testimony and then additional testimony that is provided. But our statement is very simple and direct. Missouri public employees do not need this law, HB 1722. It would impose significant and unnecessary barriers on Missouri's hard-working public employees who want to belong to a labor union. These public employees are already among the most overworked and poorly compensated in the nation. Adding crippling bureaucratic regulations and taxes on their organizations that will make it nearly impossible for Missouri's teachers, firefighters, nurses, and other public employees to exercise their constitutional right to organize is just plain wrong. Morally, we have a responsibility to support the worker and their family. This bill would only put more stress and insecurity upon their jobs, professions that are already high stress and service to others. On behalf of clergy from across the state and the Workers' Rights Board of Missouri Jobs with Justice, both in St. Louis and Kansas City, I ask that you oppose 1722.
Any questions for the Reverend? Not appearing. Thank you very much for your testimony.
This testimony?
You can just leave it there on the table and we'll pick it up.
Thank you very much.
In support, Michael Hafner.
Mr. Chairman, members of the committee, thank you for the opportunity to testify before you today. My name is Michael Hafner. I'm Director of Government Relations for the Missouri Century Foundation. Missouri Century Foundation, quickly, is an organization that was created last year to promote forward-looking free market policies that ensure the financial health and stability of our state for our current and future generations of citizens. So this bill, given the significant increase in government union membership over the last decade, we believe that it is time and frankly overdue for Missouri to consider the common sense pro-worker reforms put forth in House Bill 1722. Those testifying in opposition today will claim this legislation is anti-union. It's certainly not anti-union. We firmly believe that a union should exist and work for its members. And House Bill 1722 only includes reforms that will benefit the government union workers of our state by holding unions accountable to their members as well as to all Missouri taxpayers. And we believe this is common sense legislation that brings accountability and transparency to government unions. I do want to just quickly address the fiscal note that we've heard discussed. Legislation filed last year by Senator Onder had a fiscal note of $1 million. This one, I think, is over $4 million. Representative Braden mentioned that his bill last year had a fiscal note of next to zero. We sincerely believe that this can be done in a way that's almost cost neutral to the state of Missouri. This bill, I think it has provisions in it that allows for online voting, for televoting, that's open for a certain period of time, that's secure, that people can call in, log online, that secure pins, and vote for their representation. And again, it doesn't have to be burdensome to the state of Missouri. Again, just to reiterate the four main provisions, we are in full support of representation renewal elections every 2 years, collective bargaining sessions open to the public, disclosures of financial reports, and we think that this is a good common sense free market bill, and I would urge committee members to support it.
Questions for Representative Carpenter?
Could you remind me who you're testifying for?
Sure. Our organization is Missouri Century Foundation. We're an organization created last year to promote free market principles and legislation in the state of Missouri.
Okay,
so we're based in St. Louis.
And so you were just created last year? Correct. So like, who funds you?
We have a number of people that support us within the state and around the country that advocate for pro-good government reforms and free market principles. And we follow every letter of the law in disclosing donors.
Well, I'm sure that's true. I really don't know anything about the organization. I'm sure some of the folks in the room can enlighten me afterward. But, you make the claim about this is pro-worker and it's not anti-union. Why should I, as a representative, take your word over the word of the actual public employee unions, their actual members, organizations like Jobs with Justice that work with these folks every day, religious folks like we had testify before you? So the people who are directly involved in the process, why, since they're all telling me that this is bad for them, it's bad for the organization, and it's bad for the workers, why would I take the word of you who work for an organization that has nothing to do with this industry? And you said your organization only came into existence last year. Why would I weigh your testimony more heavily than people who have a direct stake in this?
Sure. Good question. I think, and I think I would relate that to, I think at times, our elected officials have to take votes on issues that they're not necessarily involved in the particular industry quite often. From our standpoint, we believe that this will bring accountability and transparency to public sector unions, and frankly, a lot of unions, their argument is that this is burdensome on them. The reporting requirements, again, this legislation does not outlaw unions. It's not right to work. We believe it's a good government piece of legislation, of reform legislation that brings accountability and transparency.
Okay, so, but is it fair to say that you're asserting that your argument that it's pro-worker is a stronger argument than the argument of the actual workers and the actual unions and the actual organizations like Jobs and Justice that deal with these folks, that you're correct and they're incorrect about whether or not it's pro-worker? Is that, I mean, at the end of the day, that's your argument?
I would not, I'm not arguing that my view is greater than theirs in any way.
But it's more accurate, according to you, right?
Again, I would not, I'm not here to argue whether their view is wrong or right.
Thank you, sure.
Other questions? Representative Grant.
Inquire. And, you know, we've talked about unions representing the people and the ability to have that worker, you know, choose whether they're even, you know, represented by a union or that union's even a part of that employer any longer. Now, what's kind of the average age of these unions that have come and testified on since they've been certified as a union in that workplace to now? I mean, what's average age? I mean, what'd you say? Do you know?
That's something I would have to look into, and I'll be happy to provide you.
I think that's what the purpose of this is to allow the workers over a certain amount of time. Now, is 2 years too short? I mean, we can argue the timeline, but I see unions that have been in place for 60 years, and the actual members, would have to go through a monumental task of trying to decertify, even though they may feel that these workers, would be on their side. They don't know, but they don't want to put their family and their neck out on the line, and I think this just allows, a mediator to come in and to certify whether they want that representation or not. So I totally agree that the free market, regardless of how long your organization's, been there, I think that it allows for that. So thank you for your testimony.
Other questions of the witness? Not appearing. Susan Bartles.
Good afternoon. My name is Susan Markulis. I'm Council Executive Director for AFSCME Council 72. And my intention was to basically submit written testimony from the president of our council, who is an actual worker at Bell Fountain. She's the president of our council. But I really, just a couple of points, if I may. I think one of the representatives talked about, workers who want to decertify the union and having a target on their back. That characterization is somewhat offensive because many workers who actually want to organize a union have a target on their back as well. And decertification is one of the easiest things for workers to do. And it comes regularly. And the fact that folks have had their unions for 60 years means that they have not decertified them. There is a process for this. The mechanisms that are cited in this bill, it's already been said, but they already exist. If you're a local union president, a recording secretary, you would look at this and wonder, and your mouth would drop that we're actually considering this, because within every local, within every council, the mechanisms for accountability and transparency exist. And so it's an overreach. And the other part of this is collective resources of union members are utilized to solve workplace problems, which is good for taxpayers, it's good for the services, and it's good for the workers. Incorporating or overlaying all these myriad of extra requirements means that our precious resources, the union reps, the steward trainings that we have, all of the things that we do, there's going to be less resources for that. Thank you. Any questions?
Questions for the witness? Not appearing. Thank you very much.
Okay. What do I do with this?
Just leave it there, Representative. Mr. Ken Vegas?
Good afternoon, Mr. Chairman, members of the committee. I'm Ken Mendes. I'm here today on behalf of the Missouri AFL-CIO, and President Mike Lewis could not be here today as he has to be in St. Louis at a meeting, and we wanted to go on record in opposition to this because this bill places undue hardship and constraints on employees' rights to organize and bargain. And I also have a testimony for the sheet metal air rail and transportation.
Thank you very much, sir. Are there any questions for the witness? Not appearing. Are there others here who wish to testify in support of this bill? Not appearing. Are there those here who wish to testify in opposition to the bill?
Chairman, members of the committee, Mark runs on behalf of the Missouri Fraternal Order of Police. Just a couple quick points. The fiscal note, obviously, that talked about already, and it needs some work. We've heard that last year it was 0 to 200,000. This year it's off the chart. So we think that needs to have a good hard look taken at it. The other thing is there's a section in there that talks about in the election you have to have a majority of the members of the bargaining unit, not a majority of the members voting. And that would be kind of like saying that in order to be a senator or representative, you have to win your election with a majority of the registered voters in your district. So kind of need to take a look at that one also. So we appreciate Representative Weeman's willingness to work with us on this issue, and we'd like for you to take a while before you move forward.
Any questions of the witness? Not appearing. Are there others here in opposition to the bill?
Hutchinson with the Communication Workers of America, just handing in written opposition.
Thank you very much. Any others in opposition to the bill? Not appearing. Are there those here for information purposes? Not appearing. This closes the hearing on House Bill 1722. We will now hear House Bill 2063. Representative Matthews, go ahead when you're ready, sir.
Thank you, Mr. Chairman and committee. For the record, I'm Kirk Matthews. I represent